Hi, everyone. I'm immigration lawyer John Khosravi. Thank you for joining us today, August 25th, for our regular Q&A live, taking your general immigration questions, provide some general education about the U.S. immigration process because it's confusing and there's a lot going on and a lot of changes. So I come live every Wednesday for over a year now. And I changed the time to 6 p.m. Usually it was 5 p.m. I need to get the notices out, but we're still half an hour and sometimes longer taking your questions. And I also give free consultations as a raffle. So if you're watching the live version of this, like, subscribe, and put it out there that you like to have a consultation. And then I will every 10 minutes or so name somebody who won, and we'll send information on how to get the free 15-minute video consultation. So we'll talk about your case and get some advice there. Other than that, then let's get it started. All right, everybody. Thank you so much again for joining us. We're setting up right now. We're live on TikTok. I see we have 5 people in that group, Immigration Lawyer John. We also find us on LinkedIn, Facebook, all these other places, and the clips of this on the JQK Clips channel. So we get the best questions with the answers, and we put it on JQK Clips. I think you'll find that interesting and like it. But before I start, I want to talk about something that's it's a confusing form that I want to mention. It's called Form I-824. And it's a form that has many different uses, but I was watching an old video I did. I thought I'd bring some, I talk about it to give you some guidance on it. So there are different situations where you need the USCIS to take an action. And the two of the most times that I've dealt with the need for this I-824 is this. You may have a situation where you start a green card case inside the United States. So you get married, you have a case pending, and then for some reason you have to leave the United States and you can't come back. We already have started your case in the United States. And for USCIS to send it to the foreign embassy for continuing and completing the process, they won't just do it willy-nilly. You have to submit this form and wait a while to get it. Unfortunately, the form usually takes a while to do and it costs money, but that's the process for that. Another scenario that pops up where you need the I-824 is if someone, was like, let's say, applying for a green card. They got the green card in the United States, but their spouse or child who could also get a green card because of that relationship, they're overseas and they're not coming to the U.S. anytime soon because they may have school or work that's keeping them outside the United States. So the primary beneficiary gets the green card, that applicant, and once they're done, they should have filed an I-824 to notify USCIS. Now that my case is finished, please send it to the embassy so my immediate relative or close relative that's part of the case could also finish their case overseas or outside the United States. It's not always overseas, sometimes Canada or Mexico. But that's the point of the form. Now, the problem is that it usually takes a while. You have to follow up on it, call USCIS. Although it's supposed to be something that's automatic that you do beforehand for it to be automatic, it's not always the case. So that's something I want to mention. And we got some questions right now coming in about the COVID-19 vaccination and immigration. So I think that's a great question to start. Jordan A350 is asking, that's a COVID-19 vaccine now mandatory to get a green card? What a timely question to ask. So yesterday they had updated the CDC website, and USCIS updated pretty much today, saying that if you're filing for an immigrant visa, this is a green card, there's already a set of vaccines you have to get: Tdap, MMR, the flu shot if it's during the winter, potentially a couple more. And if you had the vaccines already, you don't need to do them again, but you need to show paperwork that you've gotten them. And they made it mandatory that as of October 1st, all cases where a green card has to be decided to get a green card, those people will have to have had the COVID-19 vaccine. So, okay, a lot of people have it already, but I have a lot of clients, and enough, that are saying they're worried about this. They don't want to get the vaccine. I have to respect their wishes. What do? We have to try to get a waiver. And to be quite frank, that's not something I've handled before because all my clients have gotten them. But now, researching the situation, getting a waiver of the vaccine requirement is technically possible, but it's up to the discretion of USCIS and the officer reviewing the case. And it's not an easy thing. For example, they talk about if there's some moral or religious grounds for it. And so you have to show that, you maybe generally do not get all the vaccines. So if you're picking and choosing, that may not work. You have to make a good argument and see what they say. The other options when it comes to this stuff is maybe if the doctor could confirm that the person is going to get maybe sick if they get the vaccine. They have some sort of documentation to show that, and the doctor can write it up. Yeah, that might be a way to do it. Or you have some sort of health conditions that prevent you from getting it, or the doctor makes a decision that it's not appropriate in your case. So it's not, there are ways around it, but it's going to be hard, and it's not going to be easy. But if you're worried about that, you'd want to get your case done before October 1st. But the thing is, we have no control over this of how soon they're going to decide a case. So the case that have that green card pending, I'm not sure if the case is going to get done before cells. Now, come do the vaccine. So thanks for the question. We'll see what happens, but it's a problem for a lot of people. It is a follow-up question. What if I take the COVID-19 vaccine not approved by the U.S.? We'll have a problem. For example, AstraZeneca. The CDC has the website, and even USCIS has a breakdown of what they find acceptable and don't. Just check out that website, and they might update it. So check it out and do whatever they say there. We have a question from Srinivas, a regular. When the I-140, that's an employment-based green card petition, is approved, does it make any difference between EB3 straight and EB3 downgrade from I-485 processing standpoint? There are nuanced differences. I don't do these kind of cases where someone's doing EB3 downgrade, so I'm not a good resource for questions about that. But there are some technical stuff and some things that happen. If, for example, if you're doing pre and processing, if you submit it straight or you do regular processing, then pay for an upgrade to pre and processing, colleagues have noted some differences in processing. But I'll talk with an employment-based immigration attorney about something like that. Our next question, Alessandro Diop asks, what's the difference between the I-130 and K-3 visa? And it's the fee the same? Isn't the fee the same? Well, no. I mean, an I-130 is a marriage case. If you're looking at it between a K-3 and I-130, I-130 is when you submit a form for a family member. But if you're looking in the marriage context, the I-130 is you're married and you're starting the case. Once that's submitted, you can submit a K-3 through Form I-129F to request that USCIS expedite that so that the foreign spouse can come to the United States faster and finish up the green card paperwork here. Now, there is no fee for the K-3 Form I-129F if submitted after the I-130. The goal is just to maybe expedite the I-130. There's only a handful of these a year, maybe let's say there's 10 a year if it's a lot, of K-3 being approved. K-3 was necessary back in the day when marriage cases would take more than a year. Now, for the I-130 to be approved, but now it's not that big a deal, so it's not something that immigration attorneys file. But again, there's no filing fee for it, but it's an option. Some people want to try to push the issue. I don't like generally doing the K-3 because what happens is they turn a marriage green card case, which first you file the I-130, and once approved, it goes to consular processing, and you finish up the work at the embassy. It causes them to bypass getting the green card at the embassy and just getting a basic visa to enter the United States, kind of like a tourist visa, and then finishing up the green card process here. But what that leads to is the foreign person, the foreign spouse coming in, not having a work permit and just sitting at home for many, many months, 6 months, a year, not doing anything until their green card interview. That's really hard in a lot of couples. They want to come here and work and start their lives. So that's problematic, and it increases the fees and costs and all this kind of stuff in general. So it's not something I recommend unless people really want to do it. But mentioning these marriage green card cases, I have a guide called the Ultimate Marriage Green Card Guide, the best one out there, frankly, even though compared to paid ones. This is free. Just go to marriageimmigrationlaw.com. That's marriageimmigrationlaw.com. And send it and download the Ultimate Marriage Green Card Guide. A lot of information there that can help you go through all this process. But thank you for the question, Alsan. Donya asks, do you have any info regarding who has the green card, regarding who has green card and stuck in Afghanistan, not able to get the firm? Your question is not clear, Donya, but I don't really have any advice or information on Afghanistan. If someone has a green card, they should try to get out of Afghanistan probably, because if the airport situation is not working out, and then try to fly to the United States with their passport and their green card. Tony asks, how long does it take to make a decision on the adjustment of status from I-485? It's a green card application. Interview held 3 weeks ago. There is no time. It could be years. It just depends on what the officer wants to do, and if there's investigations needed, or if they lose the file. So there's no timetable on that. Okay, so Srinivas follows up. I filed my adjustment of status I-485 along with medicals in October 2020. Now I have COVID vaccination. Should I send the report copy? I would wait for USCIS to make the request. That's a better way to do it. I don't like to just send stuff into USCIS. I mean, it's not that much of a loss if you want to send a copy, but they may ask you to go to a civil surgeon and have them. They haven't really specified the procedure of what to do, so I don't really have a clear answer because they haven't, told us what to do. But usually, it's best to wait for USCIS to reach out to you rather than you on your own sending them stuff. Okay, next question. Donia follows up. I did fill it up so many times, but couldn't get an info. My parents stuck there with green card. Donya, I'm not sure exactly the way you're writing this out. The grammar is making it hard for me to understand. I'm not sure what you filled out, but if your parents have a green card and passports, maybe they could try to go to Pakistan. Maybe they could fly to Tajikistan somewhere just to get out of Afghanistan and then fly to the United States. Unfortunately, I don't have any more information on that. If they have a green card, they're allowed to come to the United States if they haven't violated their green card status. But then it comes a practical aspect of finding a plane to get on, and I just don't have any guidance on that. But I do want to mention who the winner is of our raffle. So our first free consultation is Joadin835. Thank you so much for watching and your questions. Just take a screenshot of where you're watching so I can see that your screen name you're using here is yours. And then email me at info@jqqlaw.com, and I'll reply with a link for you to schedule the private video consultation. I think that'll be pretty cool. And as a reminder, the Ultimate Marriage Green Card Guide is there. Just download it at marriageimmigrationlaw.com if you want to know what's going on, strategize, and get the basics between how to do a fiance case or marriage case. What's going on there? Go to marriageimmigrationlaw.com. And if you did want to get a free video consultation, those watching live, just like and leave a comment, subscribe as well, and say that consultation. And my wonderful assistant Kayla will announce one behind the scenes to me. Will name your name off. And I guess one follow note, I don't have really answers on timelines if you're asking stuff about that, but we'll take this next question. Alessandra asks, hello, sir. Can you please elaborate more on the 90-day rule and whether it is in the USCIS policy manual? So the 90-day rule is something that confuses a lot of people, including lawyers. I've seen a lot of lawyers not understand it or know what is going on or just heard something and then run with it. The Department of State has a thing called the 90-day rule, which is if you come in on one visa category and do stuff that doesn't match that visa category within the first 90 days, they may assume we did fraud. For example, you come on a tourist visa and then you start working within 90 days. They say, oh, you weren't intending on coming with a tourist visa. You lied to us when you applied for that tourist visa or at the airport to the airport officer. You were really trying to come to work, so we may accuse you of fraud for that. That situation doesn't happen as much, and that's not the good thing. The thing that worries people is usually in marriage cases, and this is what lawyers are scared of and they scare their clients about is if you enter the United States with a tourist visa and you get married within 90 days to file a green card case in 90 days, the USCIS Immigration Department in the US might say, oh, your intent was just to get married from the start, and it was not to come as a tourist, and you lied to us, and they may deny your case for fraud. There's very, very, very few times this has ever happened in regards to a case where you're married to a U.S. citizen. They generally don't do that. There's discretion of the officer, but it's not generally something that happens. But if you had another category, for example, you're marrying a green card holder and you do it really quick within 90 days, they could look at it. And so the USCIS policy manual, USCIS is the immigration department in the United States. They don't have a 90-day rule. They just say we look at the totality of the circumstances. It's Department of State and the embassy system that has that. Historically, there was a thing called the 30, 60, 90-day rule, which is if you do get married, file a green card within 30 days, they'll assume it's fraud, and then 60 days they may, and then 60, 90 days they may or may not, blah, blah, blah. That was never really the case. And again, there's cases, there's Board of Immigration Appeal cases that say for, like, if you're married to a U.S. citizen, not to hassle people about this. I filed cases, where they got married immediately after entry. At the same time, I've seen people get married within the first day and file the next day and be okay. But the thing with immigration is always up to the discretion of the USCIS or embassy officer you're dealing with. So you just want to be careful. First of all, obviously, don't lie, don't misrepresent your intent. Just talk with a lawyer, and best really talk to a couple of different lawyers, because I've seen a lot of lawyers really almost destroy people's lives over this, or have them submit waivers when it's not needed, making admission, very foolish kind of stuff. And this frustrates me, seeing this bad lawyer, even from lawyers that have been doing for a while, even lawyers here on YouTube doing videos. They've got videos about some nonsense like this. And I've had clients talk with them and talk to me, and they almost had their lives ruined for not properly understanding the 90-day rule. This was a general overview. It's much deeper. We need to talk about what's going on in your specific case if you're having this issue to see what's appropriate and what's not. But again, I think a lot of people, a lot of the information on the internet and on videos about the 90-day rule is 100% wrong. So talk to different lawyers, schedule a consultation in my office if you like, and I give you my opinion after knowing all the facts of your case as to what's going on and what's appropriate. But Hassan, thank you for your question. It's a really important one. 29 Super C1 on regular asks, good night, Attorney Khosravi, good to see you. Do you have any comments on Judge Mehta's ruling on the diversity visa lottery winners gain their visas, but limited to 9,095 persons? So I'm not following this that closely, but the diversity visas, the green card lottery, every year the U.S. can give up to 50,000 green cards to people randomly chosen. Normally, probably 30,000 people actually get the green card. Because of the travel bans and all that kind of stuff, people have had problems. They're not getting their green card interviews, and they sued about it. And I think the lawyer Curtis Morrison is a lawyer on it, and Judge Mehta is a judge on it. And I just read some tweets, so I haven't read the whole thing, but apparently they're limiting the number of winners, and they're randomly going to be chosen. It's kind of a bizarre system that they created. I just wish they would give it to all those that were part of it or part of that class. But I haven't read the case, so I don't want to comment too much. I just read what people have said about it on Twitter. But it's in one sense, it's good that some people are going to get it, but it's kind of arbitrary if they're going to randomly choose people up to some limits. I don't really understand what the impetus or what that logic is based on, but again, I haven't read the decision, so I don't have more than that to talk about it, but thank you for the question. Sahar asks, how U.S. citizens can help to bring their family from Afghanistan, especially in this situation. I'm really sorry to hear that you have family in Afghanistan. The situation is dire. I'm not handling this particular kind of cases. I really just focus on marriage cases in my office, and I generally know about everything else because I teach immigration law. But usually people do what's called humanitarian parole. But, you got to imagine there's a lot of people in your situation and a lot of people asking for it. The immigration department can't even get marriage cases done in a timely fashion, or even a reentry permit or something like that. Historically, getting humanitarian parole, it could be a few months, it could be years, and they could just lose your case. I've seen all of that happen. I've seen people get it approved and then denied a week later, or like returned. So that's maybe one way, but talk with attorneys who are handling these kind of cases, see what they have to say, talk to several people. I'm sure there's going to be a cohort of lawyers that are going to be abusing Afghans and making money off this and not doing anything. But try to find some people with good reviews, talk with them and see what they can do. But there's not much you can do, to be honest. So I'm not really optimistic, to be frank. But do what you can. It's just not something my office handles. I don't specialize in these kind of cases, humanitarian cases. So I'm not a good resource for more detailed, nuanced stuff about a situation like this. But thank you for your question. Artie asks, hey there, John. Good to see you. What do you think about interfiling medicals before receiving the RFE? Do you recommend it? I don't. I talked about this earlier. I don't like sending an important document like that unless you're willing to, get another one. So let's say you mailed it in, USCIS lost it because it was not associated with your file, and then you're forced to get another one. Then that's the thing. I have a colleague who knows how to make barcodes. They're able to make the barcode needed. So when USCIS gets a document, they can scan it and attach to your file. I kept she did a breakdown of how to do it. I kept a copy of it, but because I haven't needed to interfile or done so, I'm not doing it. The reality is this RFE kind of for the medical interfiling you're talking about. These are, for those who don't know, when you have a green card case pending, many times, in my office in particular, we don't submit the medical checkup with the application. We do it later. But USCIS is trying to finish up a lot of these employment-based cases before the end of the fiscal year. So the government's year is not January 1st to December 31st. It's October 1st or to September 30th or whatever. And so September 30th, a lot of people who are in line for green card may not get it in this year because the government hasn't got their stuff done. And part of the stuff they need done is the medical checkup. So you want to get the medical in to kind of get things up and running. But what I'm seeing is USCIS is issuing RFEs for all my employment-based cases. I even got a whole family's RFE today saying, please mail in the medical. So the best thing to do is do the medical, have it ready, and submit it. This October 1st situation is interesting. I talked about earlier about the COVID-19 vaccine and the requirement October 1st. Probably the reason they didn't make it immediate and did October 1st is because that's the beginning of the fiscal year. They want to try to get the green card medicals for these employment-based cases in as soon as possible. And if they all of a sudden added a requirement for the COVID-19 vaccine, then it would mess things up because they have to do another RFE for the COVID-19 vaccine, and it'll delay the case so much that the green card numbers for employment-based cases in this fiscal year would run out and it'll be a disaster. So that's an interesting thing. That's probably why they did that. That's a neat one right there. But going back to your question, I don't typically interfile, but it's up to you. If you want to be safe, just have a backup because I mean, do another medical if needed. Do it quickly. You might have to pay for it, but just be safe. That's the thing to do. Really quick, I want to mention our free consultation raffle winner. So for those just tuning in and watching live, if you like, subscribe, and leave a comment like consultation, my assistant Kayla, it's every 10 minutes. So we're going to announce one right now, but another 10 minutes from now, we'll name somebody and we'll have a free 15-minute video consultation so we can talk about your case. Our winner this time is Al Hassan Teray. Thank you so much. I want you to take a screenshot of where you're watching this so I can see your screen name there. And then what I'll do is email that image to me so I know it's you, not someone else. And I'll reply with a link to schedule a free 15-minute video consultation and talk about your case and get my opinion on what's going on. As a reminder, if you are doing a marriage green card case, interested in a fiancé case, and trying to figure out what is going on, what is it? marriageimmigrationlaw.com, the ultimate marriage green card guide, the best one out there. Download it. Even if you're not doing a marriage case, it really goes over a lot of the green card kind of stuff too. But even if you're not doing a marriage case, you're going to learn a lot from marriageimmigrationlaw.com and download the ultimate marriage green card guide. Next question, I was saying, does the 90-day rule affect immediate relatives of a U.S. citizen adjusting status through marriage? Hassan, let's talk about some private, but if you're doing it in the United States, there's two cases, Matter Cavazos and Matter Ibrahim, where they've said that we don't want to really push this kind of issue about what the repercussions of the 90-day rule are on immediate relative cases, unless the foreign national has, criminal history or something like that, or they've overtly lied or did some fake documents or something like that, which both of these are rarely the case. But I would want to talk with you in private. You got the free consultation. Let's talk about that. And for others, if you had this kind of issue, just email my office to schedule a full consultation. We can talk about it and see what's going on. But thank you for the question, Hassan. Abidun asks, my employer is concurrently filing and pre and processing Form I-140 adjustment status for me. Can Form I-24 be filed for spouse and 2 kids at the same time as they're currently in Nigeria? It can. I remember the first time I used I-24, I submitted with the case, and then like 3 or 4 months later, they mailed it back to a receipt that said stamped that said received. I was kind of confused, but it ended up working out. It's probably better you file the I-140 and the I-485, get the receipt or get it approved, and then send the I-24 to show that it's been approved. Now send it over. Or at least they have a receipt. So it's probably a better thing to do, but your attorney is going to know what to do about that. So talk with them. Actually, I had a consultation a couple months ago with a woman who's a corporate attorney, that's immigration attorney, didn't know about the I-24, had no idea what to do. And her husband and 2 kids were almost going to miss out on the green card. This woman had been filed immigration for 20 years. I was very surprised to see that. So if the employment lawyer doesn't understand it, schedule a private consultation with some other lawyers, see what they say. But I'll probably, and I can't say for sure because this is general guidance, not education kind of stuff, not for your case. I'll probably wait to get the receipt for the I-140 and the I-485, and maybe just get an approval for the I-140, frankly, so you don't spend money on something like that, unless the employer is paying for it, then whatever. And then file the I-24 that way. So that you could connect the I-24 with some receipt numbers that way. But thanks for your question. Ishaq asked, they granted my husband's asylum case, but they said they get right to. Sorry, I don't understand what your question is. I'll give them, please try to redo it. Simi asked, how early can I apply for citizenship? Can I apply after 4 years and 2 months or after 5 years? I'm not sure where 4 years and 2 months comes in, but Simi, I have a full video where I break down in 15 minutes the timelines for a basic citizenship case. Go to jqqlaw.com. I'm sorry, go to youtube.com and the JQK Law YouTube page and type in naturalization citizenship, and you'll see my videos. I have an in-depth breakdown of all the timeline requirements for a 5-year-based citizenship application. You can find your answer there. PBO asks, divorce waiver I-75 on processing times. There are no processing times, really. It could be 6 months, a year, it could be 2 years. You'll need to have an interview most likely, and who knows when that's going to be scheduled. It depends on how busy the USCIS office is. So the key word is patience. Donnie asks, how long is it going to take to get a visa after the interview for K-1 visa? It could be 1 day, it could be years, it could be never. So It depends on the case and the embassy and how they're treating the case. The K-1 visa is a fiancé visa. Marsha asks, I have an interview August 30th. Any tips for me, please? Thanks. Marriage-based. It's hard to give tips when I don't know anything about you other than it's a marriage case, but you should download the Ultimate Marriage Green Card Guide. There are tips in there. Just go to the back, for example, in the practice question. That's the best thing to do. Go to marriageimmigrationlaw.com and download the ebook. You'll find a bunch of tips that'll suit you, but general like this. I have a video on YouTube. If you go to the JQK Law YouTube page where I talk about top mistakes or something like that people make, that should be able to help you as well. Hassam asks, what about the new immigration plan? Until we actually have a new immigration plan, I don't like to speculate and talk about what people in Congress are doing because this stuff changes all the time and it's not reliable. So for now, just wait for it to actually become law and we'll take it from there. Super C follows up. Do you think the Afghanistan humanitarian crisis can further delay cases in U.S. embassy and consulates around the world? Maybe. I mean, they may have to move staff to one location to help them or take officers from another place to help them. It's a mess, so it's not clear. But, when people ask how long a case takes or something like that, look how incompetent the U.S. government was, where something where they had so much time to plan and kind of work their way through this, they completely dropped it. So when you're looking at USCIS or the embassy system saying why they're not, having the things faster, this and that, the embassy, when you're waiting regularly for your time, you're in a peaceful location waiting. Compare that to when there's a real priority, people's lives are at stake. Look how they treated that situation. So you can imagine how much even less of a priority your cases are, unfortunately. They're probably not happy for me to say that, but the reality is we're seeing what's happening with these slowdowns. A lot of it is because the higher-ups not giving the finances and creating issues. The whole system is a disaster. So just take this as an example of why things are taking so long. It's just government bureaucracy at its worst. It is what it is. So the pandemic's in there that's affecting things, but there's got to be solutions. Someone's got to take the helm and kind of free up the red tape. But unfortunately, I don't really have an answer to that. It's just expect more of the same, which is not good. Ishak asks, they granted my husband's asylum case, but they said they get right to do they have any chances to appeal the case after granted the case. I don't understand your question. You're saying your husband's case was granted, and then I don't understand what happened. You're saying next, and you're saying, can you appeal the case? This doesn't make any sense to me. So just please contact the immigration attorney in private and discuss it with them. Sriwani follows up. When my priority date is current, does the H1, H4 visa extension given only for 1 year? If yes, why is so? It's not that your priority is current. When you have an I-140 pending, and again, I don't do claim-based cases, but there's this rule where you keep renewing your H1, H4 indefinitely until the case is finally approved. I think the regulation says you can only renew it. I think it's more than 1 year. I think it's like 3 years initially, then 1 year at a time. But Shrivani, I don't handle H1, H4, EB2, EB3 cases. So talk with your employer's lawyer, or I can find the answer. I just got to go research it. Schedule a private consultation, and we can talk about that. Eki asks, hi, attorney. Can a person who's trying to take USMLE exam for national graduates for doctors acquire a tourist visa? What are the requirements? You can always apply for a tourist visa. If you want to give a test, that's fine too. The State Department's website breaks down what you need for a tourist visa. I think I did a video on that on YouTube at JQK Law's YouTube page, a whole video. So when you take what's the requirements, that's too big a thing to talk about because I don't know anything about you to see how it fits you. So you can schedule a private consultation and we can talk about that. But in general, you have to file for a tourist visa and fill out the form, have some documents, go do an interview. You may get approved, you may not. But best of luck though. Tanya follows up, good night, attorney. Thanks for the info on where to find details on the COVID-19 vaccine. I got 2 shots, AstraZeneca vaccine in Jamaica. Was wondering if the U.S. would accept me as COVID vaccinated. Probably would. I haven't read in detail what the new requirement is and which vaccines they accept or don't. They issued a statement on this, so you could probably read that and enhance that. But I haven't gone too deep into it yet. This is all new stuff that happened in the last 24 hours, so I didn't review all the newest stuff because it doesn't go into effect until October 1st. So we have some runway there. And Rashi asks, I have an interview on the 30th of August. Any tips? So we discussed that already. Terry asks, help my brother file K1. Does he need to come back before the immigration case continues his case? Terry, I'd have your brother contact me, schedule a consultation. There's just too much things I need to know, and your question is just not clear. It doesn't have enough information, so I can't answer that. Dave Miller asks, how long does it take to get a Workman advanced parole? Hopefully 8 to 10 months, and hopefully faster than that, but it could be 3 months, it could be a year, it could be denied. That's the honest answer. Well, I want to mention one of our raffle winners, Abidun Adegun. Thank you so much. If you're still watching live, please take a screenshot of your page where you're watching this so I can see that the screen name or the name you use is yours. Email it to me from that email. And when you take the screenshot, I can tell it's from your phone. It's not just a general thing you're watching. So I want to see your name on there as the user. And we'll schedule a video consult. Email it to me at info@jqqlaw.com, and I will set it up. For those just tuning in, my office gives out free video consultations, 15 minutes. For those who watch the live program, every 10 minutes or so, we announce a winner. We just announced our last one, Abiodun Adeogan. So it's going to be a pleasure talking with you. Let's take some last questions, and we'll call it a day. Starboy asks, I filed the I-360 and I-485 in 2018. My I-360 is approved. How long do I have to wait? Checked out the USCIS processing times at uscis.gov about how long you wait for your particular type of case. The I-360 covers a lot of different categories, so there's not enough info there for me. Aki asks, my dad's application for U.S. citizenship, he applied last December 2020, but he was denied because he forgot that he went home for a year during the span of 7 years. Can you apply for citizenship again this year? I don't know. I have to see if they accuse him of fraud in there. I have to see what year in the last 7 years he went. I got to check out the case to know what's going on. If he left for more than 1 year, 7 years ago, I got to see what in particular, if it was outside the 5-year period, was problematic for them. So just have your dad schedule a consultation and we can discuss it. Sarong asks, what's the difference between the visa bulletin and the MVC Vermont processing times? Seem like the dates don't match. Does the MVC processing time hold precedence? They're completely unrelated and different things. The visa bulletin talks about when your date's current if you're filing a preference category case, like a family-based F1 through F4, employment-based case EB1 through EB5, or doing a diversity visa lottery. The Vermont Service Center is an organization in the United States where it processes certain kinds of cases, and they have their own processing times for USCIS cases. So it's apples and oranges. There's no comparison. Sally asks, any idea why I-130 processing times for legal permanent residents is so much shorter than for U.S. citizens at Texas Service Center? The processing times are complete nonsense. They're just not something to look. When people ask me 50 times about how long things take, I'll say go to USCIS processing times, but they're completely unreliable numbers. And so people, especially a lot of people on our show, they come and say, oh no, I got the Nebraska Service Center, I got Texas Service Center. None of it matters. You could have the same case go to Texas Service Center. One gets approved in 3 months, and then another officer gets another one that's approved in a year. The processing times have no basis in facts, in reality, and which service center gets it, well, how much time, it's just luck. So that's why just be patient and let the process move its way forward, unless it's way outside what seems to be regular processing times. But don't look at this and why this and that, because there's no consistency. I have Texas Service Center cases that are faster than citizens. So I have I-130s for citizens at a service center take 8 years, and then I-130 for a spouse for green card holder take 3 months. And it's like, that doesn't make any sense. And again, the immigration part doesn't make any sense. That's why I'm kind of here trying to explain this stuff on this Q&A. Because that's why also I don't want you to overthink it too, and try to find reasons for this stuff. Don't bother. Just wait for the case to go if you file it properly. Mahomet asks, it's been 2 months. We finished our green card interview. No decision. No RFE. Should I be worried? Maybe. 2 months is a lot. I'd have to see what's going on. So Mahomet, maybe talk to the lawyer in private to see what happened during the interview, to see if something bad happened. But 2 months is getting long. It could be just could be fine, but usually it doesn't go 2 months after the interview. All right. With that, I want to thank everyone who joined us. I'll be back next week, 6 p.m. Wednesday, 6 p.m. Pacific time, to take your general green card and immigration questions, all that kind of stuff. And if you're interested in doing a fiance or marriage case, definitely check out the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. You'll thank me once you download it. You think, wow, it's a lot of good information. So with that, everyone, God bless, be safe, and I'll see you all next week. Bye-bye.